skin, believe in your health, believe in your sound, believe in your talk, believe in your walk, believe in your sound, believe in your skin, believe in your health, believe in your sound, believe in your talk, believe in your walk, believe in your sound.
Since everything starts with self, let me hold this mirror up and take a look at myself. Before I judge you, I gotta check myself. And I come to find out that that's good for my health, right? Change your mind and watch the whole body follow. So you won't hear me talking about I'm hitting you with hollows. I can't do it, got plans for tomorrow. And I ain't trying to bring my seeds no type of sorrow. Wait, cause fake rappers do fake-ish. I mean, most the basic get replaced quick. I'll never sacrifice my soul. Truth is, so I might never get 1 million records sold. But that's cool, cause I'm good with the creator. He nurtured my thoughts, so I present you with verbal flavor. You never listen to what no haters say. We pray for them, but we gon' move it this way. We moving forward, y'all.
We can do anything. We can't be worried about what they say. My brother, my sister, just believe in your sound. Believe in your skin. Believe in your health. Believe in your sound. Believe in your talk. Believe in your walk. Believe in your sound. Believe in your skin. Believe in your health. Believe in your sound. Believe in your talk, believe in your walk, believe in your sound.
I feel like George Floyd, yo, I can't breathe. It's hard to conceive on why they wanna kill we. I think they wanna break our spirit, the youth won't hear it. We die over loose, these cops scared to quit it. I send my love to Eric Gardner's family, cause them pigs went and took away somebody's daddy. Sandra Bland, Trayvon Martin, Ahmaud Arbery, the world sees what's happening. Yeah, so in the midst of our hardest pain, we believe in ourselves and face our darkest days. You know, they be mad when we come together. So after the protest, stick together. Take the pledge, I will fight but won't kill a brother. Cause I can't take your life if you are my brother. So I'ma send you love, not one shell casing. Believe in yourself and change our situation. Yeah.
Believe in your skin, believe in your health, believe in your sound. Believe in your talk, believe in your walk, believe in your sound. Believe in your skin, believe in your health, believe in your sound. Believe in your talk, believe in your walk, believe in your sound.
All right, y'all know what to do. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. We're gonna go ahead and get right into it. This is gonna be a quick live stream, but I see we got everybody in here. Thank you to everyone that's tuning in. Oh my gosh, this is gonna be an interesting one. I know it's a late afternoon live stream, but thank y'all to dropping the 1s in the chat. Let me see how we looking up in here. We should be looking pretty good. Ooh, I feel like we were just here. Looking all crispy and clean on the screen. Welcome, y'all. Welcome back to our second live stream of the day. Another YouTube live stream and the Music Morning Show in the afternoon. I'm your host, ClassE Beats of ClassEbeats.com. We're going to get into this coverage of Mounk Tounk's hearing. Now, I know a lot of y'all have probably already seen what went down. This is not one of my favorite I told you so moments, but we're going to get into it and see what happened. Judge Whitaker is going to be ruling on whether Mounk Tounk's plea deal should be revoked. Now, rewinding a little bit into what happened, Mounk Tounk, he signed a plea deal, went through all the factual acknowledgments, initialed each and every one. They read it to him in court, asked him if he understood. His lawyer discussed it with him before. and asked him, is there anything that you need clarification on? Are we clear on what's going down? He said, yeah. So then he went to his sentencing before Judge Glanville. Judge Glanville said, okay, I'm sentencing you to 30 years. 30 years probation. We get into the trial. Mounk Tounk gets on the stand and he basically violates everything that he agreed to before. Not great. Not great at all. So now we're going to get into what happened during the proceedings where Judge Whitaker is deciding whether Mounk Tounk is going to go back to jail and for how long. All right. So let's go ahead and get into it. Again, let me shout out some of the people who are in the building. I know a lot of y'all are in here from another stream, or you already saw what happened with Mounk Tounk, but I want to watch it and react to it live because, man, this is some crazy stuff here. We're going to get into it. Shout out to everybody who's in here. We, of course, have the awesome, amazing Amy is in the building, always here showing love. I appreciate you, Amy. Walter is in here. Andrea is in here. Michi, Rodu. Who else we got? Krisha is in here. Tammy's in the building. Thunder Drop. We've got Yellowbug is in the building. Anthony Thomas is up in here. Shout out to Lauren is in the building as well. Good to see you, Lauren. Elijah's in here. My dog Sean P is in the building as well. And then we've got Queen Lindsay in here. Sherman, Satin, Wendy. Good to see you. We've got Jacqueline is in the building. Nicholas is up here. And I know I missed a couple of y'all, but I'll be saying good afternoon to you guys as we continue to watch this coverage. This is going to be an interesting one, but let's go ahead and get into it. And I'll make sure the sound is good too. Y'all let me know how the sound is. Thank you, Sheila. We got a little static here. Let's skip ahead because that's tough. Yikes. Okay, I apologize. I don't know why 11 Alive is having this issue. This is rough. So for some reason their sound isn't working.
5.
There we go.
Fine.
Testify, and I
Jeez.
plea agrees to.
There we go. Yeah, I don't think did Law and Crime have it? I don't think they had it today. And let me make sure the sound is good. We should be good, y'all. And if y'all could do me a favor too, make sure you like the video on your way in. It's free and helps the channel grow. There we go.
Yes, Judge. State filed a notice of a probation revocation for the defendant as to his violation of a special condition within the sentence that he received from Judge Glanville on December 8th of 2023 as it relates to his reviewing, acknowledging that the factual acknowledgments that were a part of the plea agreement in which he entered into on December 8th of 2023. I have a certified copy of the conviction for your honor with a certified copy of the indictment, as well as a copy of the transcript of the plea that was taken on December 8th of 2023. An exhibit within that plea transcript is the plea agreement, which includes the sections, I believe it's sections 4 and sections 5 of the plea agreement as it relates to the factual acknowledgments that the defendant swore under oath during the plea that he had reviewed, then initialed each one of the factual acknowledgments, and then signed that he again understood and had reviewed each one of the acknowledgments that he initialed as part of the special conditions of his plea, that when called to testify, if called to testify, that the specific factual acknowledgments within the plea agreement were true and accurate statements, and that would be the testimony that he would provide as it relates to his witness testimony during the trial of this case. So I would present to the court State's Exhibits 1 and 2, as well as a USB drive of the defendant's testimony on day.
Since, as you know, it's only the official transcript that is the official
All right, I'm
transcript. Anyway,
I'm gonna switch over. Hold on a second, you know.
I'm not quite sure I understand.
The transcript of the plea that was taken.
Yeah, I think
on
everybody's
December
having a
8th,
sound issue.
2023. An exhibit within that plea
This one seems a little bit better.
is the plea agreement, which includes the sections, I believe it's sections 4 and sections 5 of the plea agreement as it relates to the factual acknowledgments that the defendant swore under oath during the plea that he had reviewed, then initialed each one of the factual acknowledgments, and then signed that he, again, understood and had reviewed each one of the acknowledgments that he initialed as part of the special conditions of his plea, that when called to testify, if called to testify, that the specific factual acknowledgments within the plea agreement were true and accurate statements, and that would be the testimony that he would provide as it relates to his witness testimony during the trial of this case. So I would present to the court State's Exhibits 1 and 2, as well as a USB drive of the defendant's testimony on day 124, 125, 126, and I think 127, Your Honor, but all of the defendant's testimony can be found on State's Exhibit 3. As everyone is aware, Your Honor witnessed it and can take judicial notice of everything that occurred during the testimony in which Mr. Sledge did testify. And I believe the court during, I think it was day 125, helped direct the defendant to sections 4 and 5 of the plea agreement during the testimony for him to focus on and read and to go one by one and acknowledge or disavow is the only word I could really think as to being no longer true and testifying under oath that he was violating the special conditions of his probation.
Zachary might be next. I don't know.
This time I would tender State's Exhibits 1, 2, and 3 for the court.
All right, I'm not quite sure I understand what 3 is.
3 is a USB drive with all of the testimony of the defendant. If Your Honor wants to.
And we watched that a
review it
couple
or
weeks
wants to
ago.
be part of the record.
Is that from the official transcript?
Well, it's the YouTube link, the live stream of all of the.
Okay, I'll just take judicial notice of it. I mean, if you want to make an exhibit, that's fine, but I'm not going to be relying on that.
So-
Since, as you know, it's only the official transcript that is the official transcript anyway, but I was here and witnessed it, so I will take judicial notice of it.
Judge Whitaker hates
Very
media.
much aware
I
of
swear.
that. The transcript obviously is
look at
not
the
ready
video.
as we're still in the midst of the trial.
Right.
I didn't want to overwhelm the court reporter who has been doing nothing but probably working hardest out of everyone in the courtroom. So I knew Your Honor
All right.
either could take judicial notice
Thank
or
you.
rewatch it. Can I approach it?
You may.
Yeah, and we reviewed this, y'all. This is gonna be
And can you try to use
Tough.
the mic, please?
Yes, Your Honor.
Can I, they go to the court reporter.
Nothing further from the state at this time, Your Honor.
All right. Mr. Wright,
Your Honor, may I remain seated or?
it's probably easy. You can. It's
he don't
probably
even want to
easier
stand
hear
up. Can we boo this man? Garbage. Absolute garbage.
you that way.
He don't even want to stand up. And there's Mounk Tounk right there.
Okay, I think I'm on.
Sheesh.
Your Honor, if it'll please the court, I believe, and I have already sent to the court defendants 1 through 6. Defendants 1 through 5, I believe, were already, I think my emails between myself and Ms. Love came into evidence during our testimony.
Came into evidence in the trial of the defendants that are on trial right now.
Yes, Your Honor.
Yes.
So those are sort of resubmissions
Okay.
of those, but I do think they're already before the court, or the court can potentially take judicial notice of that.
What is your Exhibit 6? I think I
Well,
only got
Exhibit
5.
6 is the one thing, and that's just a listing of my emails in December between
Oh,
myself
that's
and
this
Ms.
one.
Probably
page.
right, Loki.
Yes.
Okay, it didn't have an exhibit marker on it.
I'm sorry,
so
Judge.
that's fine.
So succinctly, I thought it best to submit these exhibits. When you look at Exhibits 1,
And
2.
those are admitted for purposes of this record, which is the probation revocation matter.
Thank you, Judge. When you look at Exhibits 1 and 2, what you see going on is plea negotiations in this case started on December 27th between myself and Ms. Love. You can see it's in the evening hours, and that's one reason I wanted to make sure that the sort of the cover page along with the attachment are part of these exhibits. At approximately 4:57 p.m. is when the email first comes in from Ms. Love. You see that a second one, Defendants 2, comes in
It's a nice jacket.
at 5:06 p.m. And at some point I respond. Those are the only two exhibits, or the two drafts, which occur on the 27th.
So what's your
However,
argument?
It's important to note that when you see the response that I send to the email at 5:06, I send that response at 8:42. And I point out specific issues with the draft that need to be revised.
Right. Yeah,
Now-
and I recall we discussed this during the trial of this, the ongoing trial as well.
Yes, Your Honor. And the point I won't belabor it is these revisions you actually see being put into the drafts. So by the time you see Defendants 3 and Defendants 4, they note that there's attachments updated to. You see that those very revisions that we requested are being put into the actual drafts. And ultimately, it was Defendant's Exhibit 4 that if you look on Defendant 6, when the email comes in, it says, use this one. That is the agreement that we thought we were executing on the 28th. And remind you,
Stop it.
Stop the cap.
He wants to. Did the state play dirty? Possibly. But at the end of the day, it's not like they initialed it and signed it and then send it back to the state and say, hey, if you need to change anything on this, go ahead and do it, even though we initialed and signed. No. That's not how it went down, Mr. Wright.
on the 28th, we're in court.
You failed your
isn't where
client.
I'm at my office, I can print it out, look at it, take it to the client like we did on the 27th. On the 28th.
Should have done your
On the
job.
28th, both you and Mr. Sledge are in person in this courthouse, right?
Correct. So the emails, if you
Mm-hmm.
notice, I never respond because I'm here, I'm in person.
Right.
So we would get it and via phone, or if they would give me a draft, to take to him, I would literally go from the conference room back to the holding area. We would go through it, go over it. But the one that we thought was going to be the executed final was the same one that they said on Defendants 4, use this one.
But are you testifying now, or are you just recalling
Well,
for me the testimony from
testifying.
previously during
It's
this
too late.
ongoing trial?
I am asking the court to take judicial notice.
I
because think
will
testified.
take judicial notice of what both you and Mr. Sledge testified to in the trial. I recall it.
Understood.
It's
So,
both of their faults, Howdy Girl.
ultimately, the last thing that I think we mentioned in our testimony was where we did take issue with some things, we said he'll have a chance to answer the question and to explain. Now, there was a big
But he is. He was. He was allowed to answer the question and explain. So what are we even talking about? And he actually did that at several points. The problem is not that he wanted to explain. Ms. Love asked him specifically, did you understand and agree to this in your factual acknowledgments? If he would have said yes, but what actually happened was this, that wouldn't have been an issue. The problem was he's like, yeah, I agree to it. Did you understand it? Yeah. Is English your first language? Yeah. Did you sit in court and we read through all of it for you? Yeah. Did you initial this line by line by line by line? Yeah. Okay. So this was the deal, right? Yeah. You signed this because you wanted to get out of jail and you're going to get 30 years probation. Yeah. But the things I signed weren't true. You don't get to do that. Mr. Wright, you don't get to do that, Antonio Sledge. The time for that had passed. As soon as you sign the dotted line, it's over.
Question and to explain. Now, there was a big problem, and I noted in my testimony that
it was too late,
number
Mr.
8
Wright.
on that version that got signed had been taken out, removed. All of a sudden it reappears and it's there. My client initialed it. Yes, it was tendered. But ultimately, here's the problem. My client has always said he does not know who's responsible for shooting the victim.
It's garbage.
He never was a participant or heard about planning the murder of the victim. And therefore, number 8 was put into evidence by Ms. Love to the court when it was a knowing statement. She knew that statement was false. That is,
Yeah, I'm not sure about that. That may be your contention, but
well, we would contend to the court that where my actual email.
What did he say? Hold on, let's run this back.
that may be.
Was put into evidence by Ms. Love to the court when it was a knowing statement. She knew that statement was false. That is,
Yeah, I'm not sure about that. That may be
can't
your
say that.
contention, but
well, we would contend to the court that where my actual email defendants 2 clearly denoted that.
it does not. That is up for debate what that denotes.
It is removed from all the drafts.
Take
and then
responsibility,
ends up
Mr.
back
Wright.
in-
That is true.
So
But your response on your defendant's exhibit 2 to item, what is then item number 4, does not definitively state anything like what you just said. He said he did not know, as we discussed at the time of the ongoing trial, could have been interpreted in several different ways. But I understand what you're saying.
and just so I
You maintain that the two of you both missed the fact that you signed, or your client signed, a factual acknowledgement that included item number 8.
correct.
And then when Ms. Love read it out orally in the court,
Yes.
and Mr. Sledge, one by one, said, yes, I acknowledge that.
Exactly what I've been
somehow
saying.
that didn't occur to you at that point in time either. So I understand what the assertion is. Here's the thing. You seem to be focused almost wholly, if not wholly, on, well, maybe there was a mistake with regard to factual assertion number 8. The issue that I see is that the state has not limited their petition to revoke probation to, he contradicted or he refused to acknowledge during the trial that item number 8. It is the entirety of disavowing factual acknowledgments, et cetera. And what got disavowed under oath in this trial was far more than just item number 8. It was item number 3, item number 4,
Number 7,
item number 5, item number
8,
6,
and
item
9.
number 7, item number 8, item number 9,
We went
item
through
number
it.
16, and then the part 5.
This is bad.
sentencing acknowledgments, number 1, number 2, number 3, number 4, number 5, number 6, and the paragraph underneath asserting that he's read and that they're true and that he understands that he's had an opportunity to discuss it and he voluntarily enters into it, et cetera, et cetera. So even if we entirely disregard item number 8 of the factual acknowledgments, there are still however many other ones that added up to.
Yep.
That the state
Which is all of them.
still relying upon. And I don't see how you get around, and maybe you have a way to get around the rest of it, and I'm certainly willing to listen. But that one thing is sworn to in open court on December 28th of 2022, and then something diametrically opposite of that is sworn to under oath back on September 5th of this year.
Yeah, in simple terms, you can't violate a deal that you signed. It's not that complicated, though. And especially after you were advised by your lawyer and you reviewed it and it was reviewed to you again. If you didn't understand at any point, you could have said, stop. You say, what now? Judge Whitaker is 1000% right. He violated this whole plea deal.
I understand your concerns, Judge. One of the things that we traveled on after taking the plea was he would be able to explain his answers if he had issues.
Can I ask you a question about that? Is
He
there
could have
anywhere in the guilty plea agreement in sentencing of your client in December of 2022 where you reserve that, where anybody, the state, the defense, or the court puts on the record that that's part of the understanding?
It is not in the written plea agreement, no.
All right.
However,
This man shook hands with the devil. He shook Miss Love's hand and said, yeah. Oh, you're going to let us explain this in court? Thanks, Miss Love. Garbage.
in evaluating my client for the purpose of this hearing, I don't think the state is denying that that is something that it was understood. Understanding it's not in the written plea agreement, but it was understood. And the other thing to also take note of, my client, when asked to make himself available, to meet with the state, to be prepared by the state, at all times would show up and do that. He was never provided or questioned it with any details such as, here, let's go over your plea agreement, these factual allegations, what questions may be asked. In other words, what you saw at trial was someone who was now, after, what was that, December of 22, was now, for the first time, being drilled or asked questions, rather, as to the specifics of all the things that he had allocated, all the questions that were going to be asked. There was no preparation of him. So what you saw was probably frustration on his part at times and shutting down at times on his part. But it was also part of the manifestation of what happens when a witness who's not a lawyer, who's not someone used to this, is getting questions fired at them.
That's what you're
And
there
at
for,
some
Mr.
point,
Wright. Oh
I
my
think the
gosh,
court
this guy is
take note that
terrible.
He literally shut down, and some of what the court saw may be more of a manifestation of being overwhelmed as opposed to trying to purposely change or diametrically say something different than what ultimately he allocated initially. So
This is Mr. Wright. I don't know what he's trying to say here, but the issue is the plea deal. I don't know why they even brought up issues with the plea deal in the first place. I mean, I guess as his lawyer, he was kind of in a catch-22. I mean, do you tell your client, hey, you signed this, so you got to agree to everything that you signed on here. So when you get on the stand and she asks you about it, you say, yeah, I signed it. Yeah, that's what I agreed to. But not just say, oh yeah, let me see that plea deal that I signed. No, I didn't agree to this and this and this. Yes, you did.
Retrospect, wish the state had actually more than
The issue is his lawyer and he
actually
signed.
prepped him like you would normally see a witness be prepared and prepped. That did not happen. So you saw a very raw witness.
Common sense ain't
recounting
so
things that
common.
happened quite some time ago, and did not necessarily say things consistent with what he said before. But it wasn't simply for a malicious intent or an intent to deceive. There were several factors, is all I'm indicating, that may well explain why it was so difficult during his testimony.
All right, anything else you want to present?
Your Honor, not at this time, no.
All right. Can the state
Anybody else you want to blame,
give
Mr.
me,
Wright?
quick rundown of what this defendant's prior history is, including any prior probation violations?
No, I think
And
Woody's
then
immunity is
I know
pretty
that the
solid.
probation officer is on here, so I'd probably need to, at some point, ask that officer if they would like to be heard as well.
And Your Honor, we would defer to probation as it relates to, I know they have a full account of his history as
All
it
right,
relates to.
you know what, I think I'm still on Zoom. Yes, Judge. Yeah. And what's the officer's name? That's Jolly. Oh, it's my regular probation officer from long ago, whom I haven't seen in the last 2.5 months because I've been otherwise occupied.
Yeah, we'll see what happens, Lauren.
Hello, Judge Whitaker.
Hello, I'm trying to, oops. Okay, I'm trying to get myself on video. I know. So that it's not a disembodied voice. Hang on.
Correct. Yeah, the state cannot give out federal immunity. Yeah, Woody's immunity. Woody had a
All right.
great
Officer
immunity deal compared to this.
All right, what is probation's, can you give me a rundown of Mr. Sledge's criminal history? And I'm sure you heard the question I just asked, as well as any prior probation violations.
Well, currently, he'd used his first offender twice, one for DeKalb County, one for Fulton County.
Well, that's
The
lucky of
DeKalb,
you, since you're only supposed to get to use it once. Okay.
yes, so the DeKalb County case, 04CR24799, that was theft by receiving stolen property, felon, and a obstruction of law enforcement officer, which was a misdemeanor.
This
That
is
was
probation
May 19th,
officer.
2005. I'm sorry.
Okay.
He used his first offender. The second case, 04SC23883, that's Fulton County. He used his first offender. That was possession of cocaine, as well as a possession with the intent to distribute cocaine. That was December 10th, 2004. The possession with intent to distribute cocaine in Fulton County was January 3rd, 2014. Again, both times, all three times, he used his first offender. The next case is 15 SC 138994. That is a Fulton County case. That is the gang participation, aggravated sex battery, attempted aggravated sex battery, aggravated battery,
Jeez.
aggravated assault, criminal damage first degree, criminal damage second degree, and possession with a firearm by a convicted felon. That was January 10th, 2018.
All right, so given the fact that he had, at that point, a possession of a firearm by a convicted felon,
It's a menace.
that, indicate that at least one of those first offenders was not successfully completed?
One
Or are we
moment.
missing a felony?
One moment.
He was a
And of course, Miss Love is in the courtroom. She couldn't miss. She couldn't
That would
miss
be correct,
this.
Your Honor. In addition, of course, the current case that he is currently on probation on. As far as previous revocations,
So, hang on. So the 15 SC, and then this 22 SC case, right? Is there anything
Correct.
between the two of them?
there's nothing in between the two of them, no.
Okay. Are you looking about prior revocations or prior violations?
Yes, at this present time, I don't see any prior revocations. There was one documentation. It's a little bit, I guess, I'm having a hard time understanding what they meant by it.
Yeah, Mounk Tounk was out in these streets, man.
One moment.
Judge, while she's pulling that up, there is a 13 SC 123423 out of Fulton County. It's a BGCSA, possession of cocaine with the intent to distribute, where the defendant received 5 years probation on January 7th of 2014,
Sheesh.
which would be the predicate or basis for the possession of a firearm by a convicted felon of the
I
15
figured
SC.
there had to be something else there. Okay,
Sorry, I should have spoken
So,
sooner.
yeah.
I apologize.
appreciate it.
We knew he was dealing drugs, so that's no surprise. And he admitted to it on the stand. That's a fact.
Yeah, the only documentation that I have regarding a revocation just said revoke closed.
He was on probation.
July 16, 2008. Doesn't really show any actual time served or any time being revoked or continued on probation back in 2008.
Okay.
So I'm unsure if that's an actual revocation that was completed.
Okay, well, yeah, it sounds like maybe that it was revoked, but it was just wrapped up in something else is how I would take that. I don't know, but, or that that a violation was found, but we don't know what that was or anything like that. All right, so does probation have a recommendation in this case?
Due to the last minute notification of this
Oh, she's gonna say no.
probation revocation, I would leave that up to the courts to make that decision.
Okay.
Dang, Jolly,
All
come
right. Well,
on.
I find there to have been a violation as alleged, and again, even discounting the item number 8. What is the state's recommendation?
She said there was a violation.
In full candor to the court, Your Honor, I'm going to leave it. The state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case, and I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
All right, well, I know that at least, I believe in the petition for revocation, the request is that the entire 30 years be revoked, is that right?
Not the
Or
request.
is, oh, you're
my
just telling
God.
me that's what he has at this point, although it can't be all of it, right? I mean, he's been on probation for at least a couple of years, and did he serve it? What's left?
He just started on December 8th of
December of
2023.
last
I think
year.
He got credit for the time. I think he was in for 2 years, so he would have
He's got 27 years
26
left.
and change or 25 and change.
I'm sorry, correct, 22.
My bad.
The exact number.
He said, my bad. Jeez. He said, my bad. I just added 4 years. Sorry. Y'all see this? Stay out of this system. This is how they handle your life. It's like, wait, what do you say? 26? Sounds good. Oh, 22? Okay. All right. Whatever. Checking off boxes,
That
y'all.
would be 27 years, 7 months, and 8 days.
All right.
That's what I thought. I said 27. He said, my
All right,
bad.
Thank you. Anything else from either side?
No, Your Honor, nothing further from the state.
Your Honor, if it'll please the court, I understand the court's ruling that there is a violation. Ultimately, I guess to some degree, while it's not clearly akin to a substantive versus technical violation of probation, it is a non-violent,
Not even close. I'll tell you all the difference here. Hold on.
violation, and I would say if the court is going to violate my client, it would be more germane to treat it as a technical violation. We have expressed to the court different thoughts and reasons for the way the testimony came out. We don't know what effect, if any, one way good or one way bad, that has had. But in terms of his violation, I would ask the court treat it more as a technical. He has one grandchild on the way, one that just came.
A grandchild?
Early this year,
Dang.
with Ms. Jaquila Freeman. So the point is, he has been staying out of the way. He's been complying with probation. I would ask the court to maybe consider if you want to put more restrictions and make his probation much more of a, not just something he's on, but something that now has more teeth to it because he's been working. He's been taking care of his family. He's staying out of trouble. He's turned that corner.
For 2 years.
Literally, it was always our hope
Y'all heard that
he
rap
had
sheet?
to come in and testify. And there was a reason the state allowed this plea to go forward so that he could step away. And in
I
doing
agree,
so,
Kel.
If you recall, you may have remember from his testimony, by no fault of his, he was a victim of a crime where he was shot multiple times and had to recover.
Has nothing
from
to do
that.
with this
So
plea deal.
we would ask the court to consider some restrictions first, as opposed to custody. And if
You're going to
do go
jail.
with custody, we would ask to consider it as a technical type of violation, not a substantive violation in which you would be authorized to give him an even greater sentence. So we would leave it in the discretion of the court, but we're asking again for a non-custodial revocation punishment.
And what does the Honorable Attorney Kel Bell say? I wish he'd found another attorney for this hearing, or the attorney should take all the blame and say, don't punish him for my mistake. Yeah, you think Mr. Wright's going to do that? Nope. And for those of you who are wondering, substantive violations are more serious and often lead to harsher consequences, while technical violations are more about smaller rule breaks. Technical violation, this is when a person breaks a minor or procedural rule of the plea deal, like missing a meeting with a probation officer or being late with payments. These violations are less serious and usually invoke non-criminal behavior, which, I mean, he might be right in this case. Y'all let me know what you think, because a substantive violation occurs when a person breaks a major significant condition of the plea deal, like committing a new crime or failing to do something important. For example, not showing up for required court hearings or not completing court-ordered programs, not acknowledging your factual acknowledgments. It's a serious breach that affects the essence of the deal. And if you look at it, Judge Whitaker said he basically, every single one of his factual acknowledgments except a couple, he said, yeah, I signed it, but those weren't true. That's the whole reason you signed the plea deal, is to get on the stand and say, yeah, these things are true. No good.
Okay, well, I don't view it as a technical violation or akin to a technical violation, considering the solemn oath that he took when he said that he understood every term within the plea agreement, factual acknowledgments, and sentencing
Big fat jerk.
acknowledgments, and understood, and in fact, orally answered that he understood when both asked by the prosecutor and the court at his plea hearing that a failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the
Which is
fact
30
that,
years.
this particular violation is a non-violent violation. But I also appreciate the fact that some of the many why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with which an oath in court needs to be taken. I actually view this much more akin to perjury, frankly, than a technical violation. And the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you have generally stayed out of trouble, and I want to commend you for that. And I really hope that this revocation doesn't set you back. But we've got to take seriously the court system. So that's the sentence of the court. I find there to have been that violation. I'm revoking 5 years.
And
And he
reinstating
will be
the balance.
continued on probation, Your Honor?
And reinstate the balance.
Your Honor,
Thank you.
Might I ask, is it possible for my client to turn himself in to make arrangements?
Look at him getting locked up. That's so
I think y'all knew when you
sad.
came in here that this was a strong possibility. So, no, I'm sorry.
He must not have told him.
All right, court is adjourned.
Look how he looked at his lawyer. He looked at him like, dang, you lied to me again?
All right, court is adjourned. I'm sorry. In here
Look at
that
Mounk
this
Tounk.
was-
Turn himself in to make arrangements?
I think y'all knew when you came in here that this was a strong possibility. So, no, I'm sorry.
Mounk Tounk probably didn't even get to say
All right,
goodbye to his
court is
family.
adjourned.
Look how he looked at him. So that man got 5 years.
Good seeing you, Judge Whitaker.
Yes, thank you. Good to see you.
All right, bye.
The only person we could hear was Miss Jolly, so the only person we could hear was Miss Jolly.
Mr. Wright's like, well, steak time.
I don't know, the sound
Jolly
of this
had
courtroom
bad.
is...
Go to the next room.
And that's it, y'all. Yeah, Henry Resilient said, damn. It's sad. It's really sad that it happened this way. And I had a feeling, again, I'm not an attorney. I'm just a common sense person. And I looked at this, I said, as soon as he started talking and brought up that plea deal, I said, he is going to jail. They're going to lock him up. Now, you could say the bonus is Judge Whitaker took it extremely easy on him. And not only does he only have 22 years left, he has to only, wow, excuse me. And I apologize for saying that. He has 22 years that he has to do on probation, but he has to be in jail, in prison for 5 years. Will he have to do the whole 5 years? I don't know. I haven't seen the sentencing, which I guess Joshua Van Lawn is in. The Honorable Attorney Joshua Van Lawn and Kel Bell are in the chat as well. If y'all could let me know, is this his official sentencing? Like, how does that work with the probation being revoked? Because I know he's going straight to jail. Is there going to be a separate sentencing? I don't know. Either way, it's really weird and really strange. And it's sad to see. I want to see what y'all think, though. But let me know what y'all think. Joshua Van Lawn says, attorneys don't have common sense, bro. God, don't say, Jesus, don't say that. That pretty girl says, this is so insensitive. It's hard to watch for sure. Thank you so much. What else? Freddie Harris said, getting locked up on a Friday never feels good. Ooh-wee. Like, you didn't give that man the weekend. Kel Bell said earlier, this just feels wrong. Well, he was set up for failure from the beginning. I mean, his lawyer, he did a little bit of his job going back and forth. He didn't review it at the end, which was the key point. He had them go down and initial everything, and even had another chance once he got onto the stand. He could say, hey, man, listen, just, I know. You got your guys over there. You said you love them on the stand. You don't want to do this to them. But hey, either you go to jail and you risk all of this going away and we're right back where we started, or you get up on the stand and you do what you got to do. I mean, I don't know. It's a lose-lose, but I mean, dang, man, at least when you signed it, get up there and don't say, oh yeah, I know y'all made me sign this, but it's lies. Everything I signed was a lie. Joshua Van Lawn says in Michigan, we have truth in sentencing, so you serve every single day. He says the question is whether or not they have a good time in Georgia. No, God, hopefully he doesn't go back to Rice Street. My goodness. Sean P says he may die in those 2 years. Don't say that. Kel Bell says I don't do criminal law, so I'll leave it to Joshua. I'm a litigator, but all civil cases. Okay. And I mean, I can do some research real quick and see. Honestly, I'll do some research and probably get back with y'all about that on Monday to find out what's going to happen to Mounk Tounk. Like, is he gone? He's in there. This was the sentencing, and Judge Whitaker said, hey, your probation, 5 years of it, you got to do now in prison, and you're going to be in jail. I know for a fact that he can appeal this, but the appeal process is going to take so long. And I believe he only has 30 days to appeal this, which is, again, crazy. Y'all, please, dear God, stay out of this system. Stay on this side of the law. It's not worth it. And once you get in, as you see, it's so difficult to get out. Thank you for our amazing resident attorneys here on the channel for giving us some insight. Sean P said nobody considered that. Nobody, his attorney, the judge, nor the state. Which part did you say, Sean? Oh, he might die in those two. Oh, yeah, for sure. I mean, they don't, like I said, they're checking it off. Mr. Wright's like, hey, Your Honor, am I excused? I got, I got to pick up my order at Moe's in about 30 minutes. So they're going home. Joshua Van Lawn says, meaning, do you get credit for good time? I don't know. That's what I don't know. That's a good question. Yellow Bug says, ClassE, I got the commercial. I'm going to Atlanta Sunday. I'm gonna stay out of trouble. I told you were gonna get it. Congratulations to Yellow Bug. I knew it. Joshua Malone says, not a good time in prison. Yeah, I know. He said, except for Diddy. Oh my gosh. That was 100% the sentencing, Joshua Van Lawn says. Kel Bell says, love is so happy right now. I mean, let's think about it. Is this, I'm going to ask y'all a poll in the chat, just real quick. So if y'all could answer this real quick, is this a win for the state? Yes or no? And y'all let me know what you think in the chat. When it comes to Fannie Willis, this is an absolute win. And I know Kat Not Wins was covering this earlier, and I said over there, like, this, she sent a message with this. And I mean, she got it done quick. Within a week, Fannie got this done. She said, hey, Judge Whitaker, get him out of there. He messed up. So she sent a message not only to him, but anybody else who signed a plea deal. Hey, if you don't want to go back to prison, you better get up there and say and do what you said you were going to do, or we're dropping the hammer. And the other thing is, too, they still have his testimony on the record because his testimony is not going anywhere. So not only did they get him to testify, and the state, in some ways, they may have made their point in saying that, hey, these guys know what they did. Mounk Tounk was a thug. He was out here selling drugs, doing all this stuff. And he tried to protect them by walking back his plea deal. And now he's in prison. Also, think about this. The jury they possibly could have watched what we just saw. Not only are we going to assume that they've been watching my coverage and Catnut Williams' coverage and the lead attorney's coverage of this trial, but I'm going to assume that they were watching what was going on with Mounk Tounk. Some of the jurors might be watching right now and thinking, dang, he messed up. Tanya says, a dirty win for them. They are so evil. I cannot get over how corrupt and evil they are. It's hard to watch. Uncle Polly's in here, said, nope, ClassE. He was going to do decades if he didn't take the plea. Violate the old. I think you meant to say violate the plea and get 2 to 3 years. That's a win. I can see what you're saying, but let me be very clear. Going to prison, jail is never a win. So if you want to say it's the lesser of two evils, fine. But getting locked up is never, ever, ever, ever a win. Joshua Van Lawn says, according to my quick research, he can get time taken off his sentence. They give performance credit and earn credit in prison, which is a good thing for him. Hopefully he'll be able to make it as long as he needs, whether that's 1 year, 2 years. And we don't know where he's going to get sent either. God, I hope he doesn't. I mean, I know he messed up and did some dumb stuff, but I hope he doesn't get sent to Rice Street. Henry Resilience in here. Shout out to my dog, Henry Resilient, in the building. What does he say? He said, it's a good thing for Young Thug, loss for the state. Yeah, I mean, I'm saying it's a win for the state. They got to send the message and they got everything out of Mounk Tounk that they needed because they got to put the factual acknowledgments on the record. Y'all got to think about that too. This is what you said and now you're taking it back? What's up with that? I see you in here, Lavisa. Good to see you. Bobby said he's going to prison. Sledge was arrested having committed no crime. He had done his time. He was coerced. Well, I mean, possession of a firearm by a convicted felon it's a crime. So that's not entirely true. I mean, he was on the video flashing the gun. That's going to be a hard one to argue. Sweetscape says they did the crimes. The state wants them to say YSL, aka Young Thug, ordered them to do the crimes, and it's not true. Very true. Phenomenal RN is in the building, said, but this plea was for crimes he had already done the time on. What does Ferry Harris say? So y'all, I think the state here to let you free. Come on now. Oh, you have to rephrase that, Freddie. Lauren said, I did something stupid a few times in 2004 and 2007, and me and Mounk Tounk the same age. He just tried to change his way a little later than I did. Yeah, Lauren, I mean, if you signed that plea deal and you got up on the stand, you're like, oh, dang, I'm looking at this plea deal now, and I'm hearing what she's saying. Those things aren't true. What would you do? What would you do having been in that position? Also, shout out to Gemini Rising for the super chat. What did she say? She says, could he be a witness for the defense? Oh, no, jeez. I mean, I guess, yeah. I don't know if he will or not, but yeah, he definitely could. Joshua Van Lawn says, dude, they're going to kill him in prison. I pray that is not the case. I mean, Mounk Tounk has done some tough things. I don't think he deserves to die. And as Derek Wright, his attorney, rightfully said, he's turned his life around. He's been keeping his nose clean. He's got family. He had to bury his mother. I mean, man. Shout out to, speaking of, Joshua Van Lawn in the building. The Honorable Attorney Joshua Van Lawn just gifted 5 memberships. If you got a membership for Joshua Van Lawn, make sure you say thank you. Taiki says that's not a message. If everybody gets individual light sentence, this RICO is broken. Yeah, but what are they going to have to do to get there, though? I mean, what's the path there, Taiki? I'll be interested to know what you think. And let me see what y'all said in this poll. Thank you to all 200 of you that answered. So in the case of, is this a win for the state? Most of you said no. 61% of you said no, and 38% of you said yes. And I know some of you were giving your reasoning why in the chat. So I appreciate that. Tone said he tried to kill Shellcal, allegedly. I don't know that that's been proven by the state, in my opinion. Samantha Crumbly says he's not Snow White innocent. No. But I think this is going too far. It was a bad deal in the first place. Bad deal in the first place. Thank y'all who are subscribing too. Mark in here says Mounk Tounk needs to get PC for a few years. If he, prayerfully, he makes it those couple of years. Ricos are meant for big fists. Giving the little dogs lighter sentences don't affect anything. Nope. Not at all. And if that were the case, they could have severed so many of these and just got rid of this Rico in the first place. Yep, Joshua Van Lon says he already was a defense witness. Phenomenal RN says, well, this should show everyone that Judge Whitaker isn't as for the defense as everyone thinks. I don't think so. Like I said, I think Judge Whitaker is a straight shooter. And I as a non-attorney, a non-judge, a non-legal professional, saw this coming. As soon as he got on the stand and Miss Love started questioning him, and he's like, I don't know about that plea deal. And she went down the factual acknowledgments. He's like, yeah, 7, 8, 9. Those aren't true. I was like, oh, man, he's done. He's not going to make it. And unfortunately, a lot of us were correct on that. Shout out to Lavisa in the building. Dropped a 2 bomb and says, thanks for the chat. Yeah, I appreciate y'all being here and reacting to that with me. Tough to see. I wanted to ask y'all another question, but I'll leave y'all with this, and you can comment if you're watching the replay in the chats too. How do you think this is going to impact the YSL trial as a whole? Because we know the state is going to have to move a little bit differently when they handle their witnesses, whether that be prepping them or even when it goes into plea deals. I don't know if that's still going on. How's it going to change how the defense moves when they're calling their witnesses? I mean, there's so many things. Like, even you see Ashley Merchant, even before all of this went down, she sent a letter, which we hadn't covered yet. She sent a letter to the state saying, hey, listen, y'all better not try and pull this Mounk Tounk BS with my client, which is Duke, Mr. Arnold. So we'll see what happens there. I don't know. Anyway, y'all let me know. Last thing for Joshua Van Lawn. He says, honestly, RICO has always been broken. It's the number one way for prosecutors to convict somebody simply by association. It shouldn't even be allowed anymore. I prosecuted for years. Man, shout out to all of our amazing attorneys who give great insight and great feedback in the chat and on this channel. Joshua Van Lawn, the Honorable Kel Bell, Javier M. Bailey, aka Javier LaFleur, and I think Roxanne is an attorney as well. Correct me if I'm wrong, Roxanne. Thank y'all for being here. I mean, we're all here to learn about the legal system, become more knowledgeable about how things work. So I thank y'all for being here and giving all that insight. So we're going to get up out of here. We're going to be live actually for another show at 8 p.m. Eastern Standard Time. If y'all enjoy music from independent artists, make sure you tune into the Song of the Night Live. We're starting at 7:55 p.m. Eastern Standard Time. I'm looking forward to seeing y'all there. Hope you have a great weekend. Shout out to, who is that? Republic Room in the building. Shout out Republic Tea Room up in here. Been a member for 1 month. Thank you for the support. Hope y'all have a great weekend. Subscribe, hit the notification bell, because I'm going to be dropping some videos over the weekend too. And you know what to do. Keep growing, keep pushing, keep it classy. We go. Peace.